Mr. Sheketoff.
Good morning, Your Honors. Robert Sheketoff for the defendant appellant in this case. I'd like to focus on the DG Ambantista issue this morning. If I have enough time, I'll try and touch on two other issues, the sanctions and the exclusion of the one black male juror. And I'm going to try and not repeat DG Ambantista too many times. I have to read it every time.
You just say DG, and we'll know what you mean.
Okay. Before DG was decided, and it's a case that I think is a very important case and a very good decision from this court. Before it was decided, in a totally unrelated trial that I had in Norfolk Superior Court, I put a client on the witness stand to testify to a version of events that was very different than the statement he had allegedly given the Quincy Police Department. And in cross-examination, the prosecutor said to him, "Do you recall that when you were at the police station, the police officer told you had a right to remain silent?" And he said, "Yes, I do recall that." "And do you recall that the police officer said to you, the detective, that you had that anything you said could and would be used against you in a court of law?" And the defendant, and I'm sure the prosecutor did not think that this was unrehearsed, but it was unrehearsed, responded, "Yes, I knew that, but I didn't think anything he made up could be used against me in a court of law." And DG goes to this issue of the fact that the human mind simply cannot recall a conversation with the kind of precision that a tape recording can. Even if you posit the best good faith imaginable, it just cannot be done. And unlike motions to suppress physical evidence, where the coercive effort we put to make the police behave in a certain way could be argued serves some function such as privacy, it obviously doesn't serve the truth-finding function in a trial. But like motions to suppress improper or unnecessary suggestive identifications, and this court's decision in DG, the coercion that we put on the police to act in a certain way enhances the truth-finding function. And
But wasn't the purpose of DG and Batista a concern with regard to voluntariness and not a concern about accuracy? If it was a concern about accuracy, one would have thought we would have said every police interview should be recorded, because that certainly would ensure accuracy.
Yes, and if I had had my choice, I would have asked this court to so decide that every police interrogation should be recorded. But the first part of your question is an emphatic no. DG is also about accuracy in its plain language. For instance, the court says, "The fact finder has a woefully incomplete and inherently unreliable version of what everyone recognizes as critical evidence in the case when there's no tape recording." And if it was only about, DG is clearly, in my view, about factual accuracy for the fact finder.
But the instruction that we say you're entitled to, where you are entitled to a DG and Batista instruction and don't get it, is not you, the jury, may consider unreliable what is said. It's you, the jury, may, on that basis alone, find the statement to be involuntary.
No, it goes beyond that, Your Honor. The DG instruction can be used in two different circumstances. One is in deciding whether or not the instruction is voluntary or not, and the other is in deciding whether or not you're going to credit this version of offense. It is like the Champa case where you have a cooperating witness where you're told to use great caution and care, believing the Commonwealth's version when they were in a position to record and they didn't. And Judge Sussman is at great lengths to explain that these differences between whether it's custodial or non-custodial, she doesn't want to get into these problems. She wants pressure on the police whenever they're in a position, basically, because they're conducting a custodial interrogation of a defendant or an interrogation at a place of detention, i.e. a police station, that they record. And if they don't record, they can offer their excuses. The excuses here were, we weren't sure he was really a suspect, we weren't sure that a crime had really been committed yet, and it would have been insulting to him.
Did you have a chance to review Woodbine, which also goes into discussion regarding to John Batista and recording? I think that focused more on the factual accuracy aspect.
I don't recall that case by name, Your Honor. Are you saying that there's a decision from this court that says that factual accuracy is not the issue?
No, the opposite.
Oh,
It
okay.
focuses on the factual accuracy or inaccuracy when you don't have a recording and you have only memory.
I think that's clear. I did try and look at all the cases. I have a hard time remembering them by name, and I didn't see any case that suggested this distinction, Justice Gantz. But I'm.
But I mean, if you're right, then then the police then would be obligated to say, "I'm sorry to tell you that your ex-wife has died. We're not quite sure of the cause of death. We'd like to talk to you about it, and we now ask you to record the interview."
Yes,
That would be the pragmatic result of all this.
and that's that has you build that on a foundation of a view of the world that I reject, which is that intimate homicide is not a very well known concept in our law. That the Charles Stewart case never occurred, and and the police don't immediately suspect the boyfriend when a woman has been probably killed. The 5 police officers, or 6 police officers, including 2 or 3 detectives, that arrived at the scene, saw a woman whose pants were unbuttoned and unzipped and partially pulled down. Her shirt was partially pulled up. She had an abrasion on her chin. Depending on which police officer you want to believe, she had only bruising that could be seen on her neck, but one of the police officers said it looked like there was a string in that bruise. They left the scene of the crime after being there for 20 to 25 minutes to go interview the ex-boyfriend. They knew he was the ex-boyfriend, although one of the detectives said he didn't know that. The second detective said that he did. Yes, and this is what I expect the police to do, because at the very beginning of a case, if you've got someone at the police station who logic, common sense, and history tells us may end up being a suspect, even if he's not a suspect at that moment in time, and you want to conduct an interview that you're going to use against him later at trial, this court has said in DG that you can do that, but there's a cost to be paid, because there's a tremendous advantage to the jury and to the judge deciding any motion to suppress, and to truth, that we put pressure on you to say it's our standard practice. We have to tape record it.
Now, was there any issue as to voluntariness?
Well, the jury was given an instruction on voluntariness. Do I think there was a real issue on voluntariness? Would I argue that if the judge had refused to give such an instruction, it would have been error? Maybe. It wasn't much of a case on voluntariness. There's no question this was not custodial interrogation. This was not custodial interrogation. He was free to leave, and he was not under arrest, and it was not custodial. But DG is not confined to custodial interrogation. And this court has said, because this evidence is so powerful, and by the way, the prosecutor pointed out the discrepancies in his statement to the police is one of the grounds, and she had 3 or 4 of them, that by itself was enough to find proof beyond, that she had met her burden of proof beyond a reasonable doubt. This court has said that you're entitled to this instruction if you request it, entitled to it. And so every trial judge is a gatekeeper in some sense. Sometimes there's actual findings that have to be made by the judge as a gatekeeper. Sometimes it's just a decision as to whether or not something should be allowed in or not by rules of evidence or instructions. But as the gatekeeper, I say that the trial judge has to look at the evidence in the light most favorable to the defendant and then decide whether or not he's entitled to a DG instruction. If in the light most favorable to the defendant, a jury could find that this was an interrogation at a place of detention, then he's entitled to the instruction. And I think that's true with any defendant-friendly instruction. That's our case law. If you're entitled to it, you're entitled to it if, in the evidence in the light most favorable to you, you would get it. But in this case, because perhaps the government's going to argue, I don't know what they're going to argue exactly, but perhaps the government's going to argue the judge has a fact-finding role here as gatekeeper. The judge would have to find that it was an interrogation. The judge would have to find that it was at a place of detention. They suggest in their brief that DG instructions occur in circumstances where there's no question. You know, everyone agrees that this was an interrogation. But this judge actually found, when pressed, he said, it partially is and partially isn't an interrogation, because you have this police stuff that I hear quite frequently. Oh, we didn't have a suspect in mind. Oh, he just babbled on. We barely said anything. You know, this is standard fare. But here, this judge actually found that there partially is and partially isn't interrogation here, and the cite is in my brief to where he actually says that out loud. And so whatever his gatekeeping function is, if it partially is an interrogation at a police station, which there was no quibble about, in an interrogation room with 2 detectives, after having separated him from the rest of the people that he came with, then the DGM Batista instruction was required.
If you're right, why does the place matter? If they had gone to his apartment, would it be different?
Well, because, yes, it would be different under DGM Batista, but
John Batista really focuses on it being in a place like the police
DG
station.
Batista, Judge Sossman talks about the fact that if we confine it to custodial interrogations, then we're going to have this big issue about where we draw the line and where we don't draw the line. And if it's she throws in a second, the court does, a second theory. It's either custodial, so if it was at his home and I could prove it was custodial, you would need it, or it's at a place of detention. And there's actually a parentheses, i.e. a police station. And I think part of it is a practical thing. You know, at the police station, you've got this stuff. You've got the recording equipment. It's clearly a conscious decision on your part not to do it.
Is that outmoded in this day and age when even...
No, I would argue that...
a few years ago now.
I would argue that DG and Batista was a compromise, should have been bigger than it was, should have been a bigger win for the defense than it was.
What about
But it's a
prejudice
very
here?
important, it's a very important decision designed to press the police to do what's actually in their best interest, not just everybody's best interest.
Want to address the prejudice here?
Well, I don't think there's any DG Batista case that you've said, or even the appeals court have said there's no prejudice. You don't go to that prejudice thing. I think DG has already recognized that this is powerfully incriminating evidence, and in this case, it was actually argued to the jury. I think it was one of the pillars of the government's presentation, these inconsistencies and quote-unquote distortions in his statement where he tried to give an alibi, which we've shown you now is very false. So they argued it. They said it was sufficient to find guilt beyond a reasonable doubt. And it was important evidence in this case. It was significant evidence in this case. So I think it's clearly prejudicial. I have something left. Can I address anything else on this topic before?
It's your time.
Okay, thank you.
Well, this was tried once with a mistrial, right?
That's Your Honor.
Was DG and Batista given the first time?
I don't know the answer to that. On the issue of the exclusion of the only black male juror, I want to point out that in its brief, the Commonwealth does not even address my two major points. And the first major point that I try and make is that I believe the trial judge made a mistake of law. I think that's what put him off the track. Because when defense counsel objected and they went to the sidebar to discuss it, the judge pointed out that a black woman juror had been impaneled. And therefore, it appears from the record he believed that that was really the end of the inquiry. The Commonwealth had passed on a black woman juror.
Well, so doesn't that suggest that what you're saying, I think, is that the counsel was making a two classification argument?
Yes.
And he was taking one.
Correct.
Right? And wasn't that really, though, the focus was on the fact, the race rather than the gender?
No.
It was the combined?
This is the only black male juror we're going to see, which in Middlesex County is, one is about all you're ever going to see. Occasionally more happens, but I think that was a mistake of law on the part of the trial judge, and that's why this issue went askew. Let
me explore that. I mean, is it your view that whenever there is a single minority in the veneer and a prosecutor strikes that person, that the judge automatically has to make inquiry as to the reason?
Mm-hmm. Well, if it's what I argue in my brief is it's a very low threshold to get an inquiry, and I think the judge rejected this inquiry because he made a mistake of law, not because he didn't think that this is the second day of impanelment. This is on the record maybe the second black male juror to be seen. The first one, there's some reference, was excused. I think if the judge thought that black males was a group, Soares, which was the first case that sometimes it's the U.S. Supreme Court that bumps this court in some direction, but Soares is a case that this court eventually bumped the U.S. Supreme Court in the direction. And Soares was based on a double principle. One was that if we're going to have juries, they should reflect, if they're going to represent the community, they should reflect the community. And the second principle in Soares was that you shouldn't have members of your specific group being kicked off the jury by the prosecution, that's like an independent and separate problem. And so this is not just any group, this is the defendant's group. And in fact, if you think, well, maybe some other black male juror showed up later on down the road, I think the prosecutor's comment that I point to in my brief at the end of the trial, where she details for the court and for the record the color and race and ethnicity and sex of every juror in the jury box, and by the way, there are no black males, suggests quite strongly that everyone knew there was no one else to point to, and by the way, we saw 6 more black males go through this selection process.
My question, I guess, is more to the point. If I'm right, and I could be mistaken, the prosecutor made some comment to say that person's familiar to me. Right. And also the person did have had prior incarceration, albeit a short one for
A prior arrest. There's
some jail time, I thought.
right, well, because the way I took the record, like you get arrested on a Friday and you don't see the court until a Monday. There was no conviction involved.
Is the judge allowed to take that into account in deciding whether you need to give a source explanation for the peremptory?
In my view, if that explanation would be sufficient, then you could take it into account. But if that explanation is not sufficient, I don't know how you can take it into account.
Well, but it's a timing question, though, isn't it? Maybe if the explanation is there, it seems to me that what our cases often suggest is implicitly the judge was looking for an explanation.
Well, but this judge specifically doesn't ask for an explanation. I think what makes this situation somewhat unique is it seems fair and clear to me that the mistake is a mistake of law, and that's what throws the process off.
Does it make any difference that the person was a black male? There was a black female on the.
Right.
What I'm getting at is, apart from the question of gender, we have the case that says if the number of minorities appear to be few, of a particular minority appears to be very small in a jury venire, then too small to establish a pattern of exclusion, then a judge would be warranted, or probably should, dispense with that component of the analysis. If there are only two, in this case, black people in the venire, I guess one had been removed, or one had been challenged, one had been selected, and there was one remaining, so there were a total of three?
Well, it's not the way factually, Your Honor. I believe that when what happened was some juror, male or female, I think black male, was excused because there's some reference to it. It's not clear how. I can't figure it out from the record. Then a black female is seated, and then this challenge occurs.
Yeah.
And
do we have any information as to how many black people were left in the pool?
all I can say is that that no one claims that there was anyone else. No one says that there was someone else, and the prosecutor at the end of the trial details with some, which I think going back directly to this, details for the record exactly who's in that box, and does not mention or claim that there was another black male that somehow wasn't paneled. So, I mean, that had the possibility of being impaneled. And I lost a case in this court where I said that white women were not a distinct group, and I was told by this court that white women are a distinct group, and you cannot use your peremptory challenges to get rid of white women. And that was a case where a white woman was not on trial. In fact, it was the defendant using his peremptory challenges to get rid of white women. This is a case where a black man was on trial, and black men are a distinct group. And I'm out of time where I would have addressed the sanctions issue.
Thank you.
Good morning, Your Honors. May it please the Court, Ann Pogue Donahue, Assistant District Attorney from Middlesex on behalf of the Commonwealth, and I was one of the trial prosecutors in this case. With regards to the Digi Batista instruction, Your Honors, Digi Batista was not required in this case because the defendant was not subject to interrogation. Digi Batista, the language of the decision, requires the instruction when an interrogation, either a custodial interrogation or an interrogation at a place of detention, it goes unrecorded. The later cases discussing Digi Batista, while they do sometimes use the word interview rather than interrogation, the facts of those cases are such that it's clear that there were interrogations in those cases, that there's no question.
But isn't the defendant's argument that, you know, those are labels and that in substance, given the underlying facts here and relationship between these parties, et cetera, this was an interrogation?
No, Your Honor, I don't agree with that. They're not merely labels. If the idea of DG Batista is we want to safeguard against the police potentially coercing a suspect into making an incriminating statement, and that's really the rationale, or a large part of the rationale behind DG Batista, that makes sense when you're talking about an interrogation where the police know that a crime has been committed, they focused on someone as a suspect, and they're trying to elicit an incriminating statement from that suspect about his involvement in that crime. That's where the concern comes into play, where you don't want the police to coerce that statement. That's not what happened here. Here, the police didn't know if they were dealing with a crime. They walked into a scene of an unresponsive female. They did see a woman on on the floor, and yes, part of her stomach was bare, but there were no graphic parts of her body exposed. She did have one abrasion on her chin. There was a needle near her body. There were broken pill capsules in the apartment. The police didn't know what had happened. They thought it could have been a suicide. It could have been an overdose. It could have been a heart attack. At the time, the way that she was positioned, they were not able to see the ligature in her neck. They didn't know that she had been strangled at that moment. Yes, the two lead detectives toured briefly the scene, and then they were called back to the police station because they were told that someone had come in stating that he had information about this woman. Again, they did not know a crime had been committed, and until they walked into the interview room and met this defendant, they had no idea who he was. They didn't know his name. They didn't know his connection to the victim except for what he told them. Later, they confirmed from interviewing the victim's family that, yes, they had been in a long-standing dating relationship. But at the onset of their interview with him, they didn't know that. What they were trying to gather from him was information about the victim. To that end, they asked him questions such as whether she had depression or any mental health issues, whether she had any physical issues, whether she had any substance abuse issues. They were trying to gather information about her that would shed light on the circumstances and cause of her death. They did ask him when was the last time he had seen her, again, trying to establish the circumstances of her death. It was in response to that question that the defendant gave this recitation of his whereabouts of the night before. The police didn't ask him, tell us where you were yesterday, tell us what you did. All they asked was, when was the last time you saw her? And he responded with this explanation of his whereabouts.
Now, where is the line between questioning and interrogation?
Well, Your Honor, this court has delineated it fairly clearly under the Miranda cases that interrogation are questions or their functional equivalent that are designed to elicit an incriminating response.
So are you saying that it's interrogation only when it's custodial?
No, Your Honor, I'm not at all. I'm not saying that at all. But I'm saying that interrogation must have the intent to elicit an incriminating response, whether or not it's in custody. And here, that was not the police's intent. The police's intent was simply to gather information about the victim from any source possible, not to elicit an incriminating statement from a suspect.
And did the judge make findings as to why the judge did not give a DG instruction?
Yes, Your Honor. On the August 15th volume of transcript at pages 112 to 113, after the testimony from the lead detective in the interview, the judge stated that there was no interrogation and that was his reason for preliminarily rejecting the defense request for a DG Batista instruction. This issue was also raised at the motion to suppress. The defendant, prior to the first trial, had filed a motion to suppress statements, and the Commonwealth argued then that this was neither custody nor interrogation.
What happened in the first trial with respect to DG Batista?
My recollection, Your Honor, is that the instruction was not given, but I haven't recently reviewed the transcript.
Same judge?
No.
Different judge. It was Justice Diane Kottmeyer at the first trial and Justice Bruce Henry at the retrial. Mm-hmm. And in any event, Your Honors, the defendant didn't actually contest the accuracy of the police statement. What he wanted to get out of raising this DG Batista issue was his argument that the police rushed to judgment against him. And to that end, he tried to draw a distinction by discrediting the police's claim that they didn't record his interview because they didn't know it was a crime and they didn't think he was a suspect. 2 days after he was interviewed, the police interviewed his wife. They did record their interview with her, and they told her that it was their policy to record all interviews. It was that contrast that the defendant wanted to use, and indeed did use, to try and cast doubt on the credibility of the officers. The judge gave the defendant wide leeway to ask questions to elicit a factual foundation to make the argument he wanted to make about that issue. He was permitted to make the argument he wanted to make about that issue. And as part of the judge's humane practice instruction, the judge also instructed the jury to consider the policies and procedures of the police department. And that's on the August 30th volume of transcript at pages 137 to 138. So essentially, the defendant did obtain the benefit that he was seeking, even though the actual DG Batista instruction was not given. The goal that the defendant wanted, I would suggest, he did obtain. So I would argue, first, the instruction was not required because there was no interrogation, and secondly, there was no harm because he did get the benefit that he was seeking. Unless the court has other questions about that issue, I'll turn to the challenged juror. The challenged juror, the defendant is attempting to make an argument that there were no other prospective black jurors on the veneer, but I would suggest
Black male.
Black male, yes. I would suggest that the judge was correct below because the defendant did not make a prima facie showing. Here, the challenged juror occurred on the second day of jury selection, and the juror was part of the second panel of jury selection. Now, at that point, the defense noted that at least one other black male juror had already been excused by the judge. So to that point, this was at least the second black male prospective juror in the veneer.
So the first black male juror was excused by the judge for cause.
He was excused by the judge for cause.
So the prosecutor never had a chance to pass on that juror.
That's true, Your Honor. That's true.
What does the record indicate as the cause?
For that particular juror?
The one that was excused, yeah.
I'm not sure, Your Honor. It was difficult to match up with because no one would.
Oh, the numbers.
Right. There's no indication.
No one said calling a black juror.
Unless someone makes an observation on the record, the questionnaires don't indicate specifically the race or gender of the prospective juror. So the only way to ascertain the race or gender of a juror is for someone to state on the record, as I did at the close of the trial, to note the composition of the jury, because I was aware that this was going to be an issue on appeal. But I would point out for the court that this occurred, again, on the second day of jury selection with the second panel of jury selection. Jury selection continued for 2 more days and a third panel of prospective jurors. No one made any observations on the record as to whether there were any additional black male jurors. So the assertion that there were none, I would suggest, is speculative.
But what's a judge to do? We're on day 2 of the jury selection. The judge probably doesn't know how long jury selection is going to go in this case. I mean, was it clear that you were not going to get a jury on day 2?
Yes, it was clear. The judge had actually set aside a week for jury selection prior to starting the trial.
So the judge looks out, sees, let's assume that there's only, sees one black juror in the veneer, and the prosecutor strikes that juror. What's the judge supposed to do? Supposed to say, well, we have 2 more days to go. Maybe we'll get a black juror on those 2 days, so I don't see a pattern? I mean, how was a judge supposed to deal with that?
I think as he did, Your Honor. I think the defense did not make the prima facie showing here because, again, there were at least 2 black male prospective jurors, and the Commonwealth did seat a black female juror. So I think the judge may have concluded that there was no bias, that the Commonwealth was not exhibiting any bias. And
no,
so
I'm from the other end of the state, and there are very few black people who appear in a jury veneer from day to day even. Mm-hmm. Is the same true in Middlesex County, that you typically see you may see a handful or you may see none?
The majority of prospective jurors tend to be white. There are usually at least a handful of black jurors in my limited experience at trials in the veneer.
And actually, could you go back to the question I asked
Yes.
Mr. Sheketoff, which is, in evaluating whether there's a pattern, is the judge able or allowed to take into account the fact that the prosecutor had said, I may know that person's familiar and that the person had some very brief incarceration?
I don't know that that consideration would be relevant to determining whether the defendant has made a prima facie showing requiring the Commonwealth to offer an explanation. Once it gets to that point, I think it would be appropriate for the judge to consider such statements in evaluating the Commonwealth's neutral reason. And in this case, Your Honor, even though the judge did not ask the Commonwealth to give a neutral reason, I would suggest that the record establishes two potential independent race and gender neutral reasons. And the first is that the prosecutor noted before the judge found the juror indifferent and before asking the Commonwealth whether they wanted to exercise a challenge, the prosecutor noted that the juror was familiar to her. And I would suggest, even though she didn't expand on how the juror was familiar to her, the fact that they were known to each other already is a fact specific to that juror that has nothing to do with his race or gender and could be a neutral, valid basis to exercise a challenge. Additionally, the juror admitted that he had previously been charged with a crime and that he had been incarcerated for 48 hours in Kansas as a result of being charged with that crime. The Commonwealth excused a number of potential jurors that were cleared by the judge who also had been charged with crimes or arrested or convicted of crimes, whom the judge had found nevertheless impartial and to be valid prospective jurors, just as the defense exercised a number of peremptory challenges against jurors whom the judge had declared impartial but who had connections to law enforcement. And I believe I cited one case in my brief where this court found that the exercise of a challenge in the sort of previous crime or law enforcement connection is a valid neutral reason to exercise a peremptory challenge.
Do we know, how many black people were on the jury?
One.
Just one?
Yes.
And were others excluded or challenged in the subsequent days of impanelment?
Don't know.
The record is silent. I could speak to my memory, but the record does not say either way, whether there were or were not.
Okay.
I'm just trying to sort out what it means to have a pattern of one. Does federal law have the same law with regard to peremptories?
I don't know the answer to that, Your Honor. I'm sorry.
And is the pattern of one focused on the strikes or focused on the number of people in the veneer?
I would suggest it's the number of people in the veneer, which is why there was no prima facie showing made here, because this was not the only black male juror in the veneer.
Well, but you could still find a pattern, right? I mean, you're not suggesting because there was two black males that there could not be a pattern found.
I also have some...
Only one who came before the prosecutor was one.
Yes, the only one to that point who had come before the prosecutor, yes. But I also have trouble determining what it means to have a pattern of one.
But doesn't the pattern of one focus on the pattern of the use of peremptories?
Yes. And here, again, the Commonwealth had used its peremptories on other bases, such as excusing jurors who had prior criminal connections.
Right. But if you were also using race, that wouldn't excuse you.
No, but the Commonwealth seated the other black juror who is known to have come before it, and also seated other male jurors who came before it. So perhaps to that end, maybe I should change my answer to Your Honor's earlier question. Maybe it is relevant to the judge's consideration.
Is the rule, is it a pattern of one, or is it because there are so few minorities in the veneer that it's impossible to establish a pattern because there are so few, so that...
Well, it's a particular kind of minority that's at issue. I mean,
Yeah.
you look at the...
It's a particular kind of minority at issue, I think.
Well, but my question is it a pattern of one, or is it because there are so few of them of a particular minority in the veneer that special rule is invoked? You could never establish a pattern.
It's that. Yes,
Right.
that's right. if there's so few, one can be a pattern because you only have.
Yeah, okay.
I guess the question is, does it mean one can be a pattern or one is a pattern?
I would suggest one can be a pattern, but was not in this case.
I mean, that's the issue, it sounds like, is that Mr. Seketov says one is a pattern, and you say one can be, but is not.
Right. I would suggest it is not. But again, I would also suggest, even if this court concludes that the judge should have found that there was a pattern and should have required the Commonwealth to give a neutral reason, the Commonwealth had 2 neutral reasons that it could have given to the judge, that the judge likely would have found perfectly valid. If there are no further questions on that issue, I'd like to briefly address another issue.
Yeah, before you get to that, I was trying to figure out what the substance was on the eye hole of the door.
It was gum. We were not allowed to say it was gum, but I believe
You were not allowed to say it was
we
gum?
were not allowed to say to the jury that it was gum. The witnesses were allowed to describe it as a gummy substance.
And what was it? What was it? I just don't know. What was its connection?
It was found on the
significance?
outside of the peephole of the door to the apartment where the victim's body was found, and it had DNA on it that matched this defendant 1 in 66 quadrillion. And it was malleable when the police took it off of the doorframe, indicating that it could not have been there for very long.
And the inference is that it was designed to keep somebody from looking in and see what was going on?
No, so she would know who was there. I thought that was the inference.
Well, there are 2 potential arguments about that. One, possibly that she didn't know that it was the defendant at the door, although the Commonwealth's theory of the case was that she was intending to meet him that night. But the other potential reason is that the place where she was in the apartment was visible from the doorframe, so it may have been to obstruct anyone from the outside looking in and seeing her body.
And it was put from the outside or from the inside?
From the outside.
Outside.
Yes. I'd like to just very briefly address the closing argument. There is a mistake in the Commonwealth's brief. On page 50, I stated that the defendant did not object to the prosecutor's statement regarding the amount of time that it might have taken to conduct forensic testing on the pants. That was an error. The defendant did raise a specific objection to that on the August 30 volume of transcript at pages 118 to 120. So my apologies. And finally, Your Honors, with regard to the so-called sanctions, the Commonwealth would suggest that these were not sanctions. These were evidentiary rulings that the judge made in his discretion to allow the jury to better evaluate and put into context the physical evidence and testimony that the defendant was permitted to introduce despite his egregious violation of a clearly worded discovery order. And I would suggest that the items that
Well, in fairness, if the evidence hadn't come out in the middle of trial in a very dramatic way, but had been produced, in a timely fashion, those contextual, you're not suggesting that the judge would have used all those same steps in order to explain its significance?
I think he could have. I think the Commonwealth would have asked for that just the same, because the relevance of the
A prior trial and all that?
Yes, Your Honor, because that's relevant to the defendant's wife's credibility. The fact that she sat through this first trial where her husband was tried for murder, that she was in possession or allegedly in possession of these clothes, and she knew the importance of those clothes to the Commonwealth's case, but chose not to bring that information to the attention of law enforcement, is very relevant to her credibility. And that would have been true regardless of when the Commonwealth learned of the existence of these clothes. So we don't know what the judge would have done because there was no motion for new trial, but I would suggest that he certainly could have. It would have been reasonable for him to make the same rulings. I would think that the only rulings that might have changed were his temporary ruling that the jury could not consider the clothes, which was his initial ruling, which he did later reverse himself on, and the instruction to the jury that the Commonwealth did not receive the clothes until the middle of trial. I would suggest that those are the only remedies, that those were the only 2 actual sanctions that the judge imposed. The judge didn't exclude the clothes, which is what the Commonwealth requested. The judge did not find the defense attorney in contempt. Those would have been sanctions, punitive sanctions, and that's not what happened here.
Just to clarify, the Commonwealth contends that the TJ Maxx photos were done after the murder or before?
I'm sorry, could Your Honor be more specific?
I guess it was all seen through a TJ Maxx video
Yes.
of what he was wearing.
Yes,
Was that before the killing or after the killing?
it was before.
That was before the
The
killing.
video, the defendant is on the video before the time that the Commonwealth alleges the murder occurred, wearing particular clothes.
And is that video clear enough to indicate that there was a drawstring on the pants?
No, you can't see that. You cannot see from the video or from any of the stills whether there's a drawstring. You can tell that they are the type of pants that most lay people understand do usually have a drawstring within them. And of course, the Commonwealth searched diligently for the clothes seen on the video and never found them. So the Commonwealth's theory at the first trial, and intended to be the theory at the second trial, was that the drawstring from those pants was the murder weapon, which was a navy blue drawstring, and that the defendant destroyed or concealed the clothes out of consciousness of guilt. That was the relevance of the clothes. If the court has no further questions, the Commonwealth will rest on its brief and ask you to affirm the judgment of the conviction of first-degree murder for the death of Maurice Antoine. Thank you.
All right. Hear ye,